oneself or others in the EOC. Well, I said in my presentation that such a category is undesirable because of the connotation, the stereotype that it encourages. And I also cited that scientifically, as backed by research, psychiatrists can't always predict dangerousness. The issue, though, of the extent to which you limit autonomy rights, it's a philosophical debate. So it means that when I say it's undesirable, it's my opinion, based on my reading of several writings and cases. But somebody else might have a different opinion, and it's something to be debated and argued that to come to our position here on what we think should be an acceptable criteria. So autonomy needs to be limited, and there are practical considerations to take into account. We need to have a discussion to work out what criteria we want to include and exclude in our acts. The reason why it's there is because it's based on traditional notions and stereotypes about the mentally disabled, and we will need to have a conversation as a society whether or not it should be there still. I hope that answers.
The point about the organization, the consortium, I'm glad to know that. All I will say is that in this age, we're becoming more and more conscious of the need for organizations with legitimacy. And I hope that that is the case, especially when it involves public funding. And there's always a need to review the organizations to ensure that they subscribe, that especially when you bring groups together, groups come together when they feel confident about representation, about process, about accountability, and so on. The point about employers, I think the point was made about employees having to spend money and so on. That can be done very simply with fiscal incentives. Fiscal incentives that's the government's way of saying, the state's way of saying that we are asking you, we put a bill of rights, a set of rights there, and we want you to do this. You know, you can negotiate now with your various companies and with your representative interests, and it could be. I mean, the first thing the chamber will say is that that's an ECA, that's an added cost. What are we going to get? But that's also the cost of doing business. So on one side, you say that's the cost of doing business and having the most competent staff, and the state may also be told, well, we want to support this and so on, so let's negotiate. These things can be negotiated so that you can come to some amicable arrangement. In terms of the elderly abuse, though, I think in the same way we have all come to understand what child abuse is, the notion of elderly abuse as being a category is something that will have to be shaped by the kind of work you're doing, a registry. And I do think that there will be quite a number of cases that you can find through the police service, but they may not yet be categorized as elderly abuse because we haven't been talking like that. It is only when the police start to put a column that says, this is under this. So your work will push the police there. And I think the social development ministry will probably have quite a number of cases of their parents and so on being cheated out of their money and those kinds of things. So I think you have a basis for starting some pioneering work here.
I'm just following on from that. What you have to remember, though, is that you have to frame that argument within the context of the laws that we have, so that when you're making the bridge between, when you are going to international law, you're going to have to make the argument, well, how am I getting there? Because in the legal system that we have, international law does not have any effect in the domestic sphere unless there is some act that incorporates that international law and kind of brings it into the domestic legal system. And I know that there is an organization called SHON, Stop Elderly Abuse Now. I don't know if that is someone that you may want to reach out to or partner with. Maybe they could guide you as you want to take this journey. But Ms. Morat is quite right. All it takes is for one person to recognize that something is wrong and to be passionate enough and to be dedicated enough, and things are going to evolve. And then with respect to the two questions about the Equal Opportunity Act, I think what we have to remember is that when that act was drafted, the convention was not yet ratified. And if we look at it through those lenses, we're better able to understand why there is this disconnect between some of the provisions in the Act and some of the provisions of the CRPD. So maybe, and what we also need to remember, and this is going back to what Ms. Morad said about NETA, and what is being articulated right now about the inherent flaws of the Act, is that one of the obligations of the state under the CRPD is to submit a report. They have to account to the committee that is in charge of implementing this convention as to what they are doing, what has been done, what has to be changed, so that all of these incongruities are going to be thrown up in the mix, and they are going to have to do something about it, particularly if civil society gets together and lets them know that we understand that these inherent contradictions exist, and we want you to do something about it because you work for us. It's not the other way around.